May it please the court, Your Honor. I, Pamela Cerda, and my partner Stephanie Garcia are here to negate the resolution. Resolved. Is race-conscious affirmative action consistent with the 14th Amendment of the United States Constitution? The answer is no, it isn't because of these following 2 points. First, the 14th Amendment is not consistent with the appeal's claim. The 14th Amendment does not allow discrimination, even race-conscious affirmative action. And second, the use of race goes against the 14th Amendment. On to my first point. The 14th Amendment does not allow discrimination, even race-conscious affirmative action. The 14th Amendment states, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of the United States, nor shall deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of laws. When going through the process of college selection, the college or university were indeed using race-conscious affirmative action.
Counselor, what's the process? I mean, what's the purpose of the admissions office for a college?
The purpose is to see, to admit or either deny students into university based on their ability to succeed throughout their school.
Okay, and succeeding in college has little or nothing to do with race directly, correct?
It has little, exactly, it has little or nothing to do with it whatsoever. Race does not determine your level of success.
Okay, continue, please.
They were indeed using race-conscious affirmative action for what would be regarded as inconsistent with the 14th Amendment. The PV cannot claim they acted in accordance with the 14th Amendment without showing the exact due process it uses for every individual who applies to the college. They would have to allow each of these people denied admission full due process as to see why exactly they were denied. By denying a person admission without showing complete transparency, it is effectively violating the due process clause of the 14th Amendment.
Counselor, on that same line there, let's say that most college admissions are filled out by a single person and sent into the college, correct? And then the person is accepted or denied from that college admissions, correct? But they never really get to see why or they were turned down or anything. So a lot of people would never really know that they were discriminated against, correct?
Correct. They wouldn't know if it was simply because of factors such as their grades or whether it was their race that was affecting their ability to enter that college.
Okay, continue, please.
The PV cannot claim they acted in accordance with the 14th Amendment, for it would be an internal contradiction of their own argument. On to the following second point. The use of race goes against the 14th Amendment as the criteria in the first place, as the 14th Amendment cannot be a criteria itself. When you use race itself as a criteria, you go against the whole purpose of the 14th Amendment in the first place. The idea of taking from one group and giving to another group goes against the intent of the 14th Amendment. The 14th Amendment was an outgrown concern on the treatment of freed males by the southern states. At the opening of the 44th Congress in 1875, Representative James G. Blaine, Speaker of the House, observed that the recent amendments to the Constitution ensure that there is respecting the rights of any person should go through the regular standing committees. This is an essential argument that can be applied here. Note that Speaker Blaine was not saying that equality was a reality, but he was saying that equal treatment of all people was a reality.
Okay, Counselor, on that same thing, that pretty much did away with the Freedmen's Bureau, and you didn't need to have a special treatment just for people that were previously conditioned as slaves, correct?
Yeah.
And then is it also analogous to what we're talking about today, where we really need to have a race-conscious affirmative action program to help out minorities?
Yes, it's been nearly 150 years since the actual speaking of the committee, and we are still seeing this race-conscious affirmative action against minorities.
Now, Counselor, there's another interesting twist to this. Abigail Fisher is what race?
She is.
Okay, and in the state of Texas, what is the largest group of students who are graduating? Okay, and according to statistics, approximately 26.9% of the graduating class in the class of 2016 will be Anglo or Caucasian. So if we use race-conscious affirmative action, who is actually the minority here?
In this case, the whites, they're literally making up a quarter or less of the population of those who are going to be applying to colleges and being denied for simply their race.
So in the way you're looking at it, either the University of Texas erred by either not allowing her to be a minority or ruling that she couldn't qualify as a minority and didn't need race. Either way, they erred.
Either way, they denied her acceptance solely based on the fact that she was.
Okay. Continue.
Okay. Equal treatment was its condition to seek after, not just a catchphrase to use. By using race as a qualification for admission, even if it is a qualification, the University of Texas created a compliancy issue with the due process part of the amendment. Accordingly, to hold one person equal access is great, but to do it because you deny another due process is not legal according to the exact same law the accused are trying to use. You simply cannot claim you are promoting equal access or equal opportunity for some by denying others the same access because of their race without due process.
Counselor, it's just transparency here becomes a compliance issue because you're not allowing people to actually find out what happened in the selection process, correct?
Correct. They would never know they were being discriminated. They would, as I mentioned, think it was solely based on their academics.
Okay.
Thank you, and if there are no further questions, I will retire and allow my partner to address the following points of error.
Okay. Thank you.
May it please the court, your honors. I, Stephanie Garcia, will be giving the arguments for the next 3 points. Please press play on my partner, Pamela De La Cheva's arguments for the first 2 points of the third point. What is the actual purpose of the admission selections in the first place? Isn't it their job to pick out candidates based on their intelligence and based on their qualifications rather than the race? This should be the real question before the court today. Can the admissions office now create their own pieces of legislation or try to change the future of students by admitting and keeping some?
Counselor, in the Bakke case, Bakke versus the Regents of the University of California, we saw that a gentleman was denied admissions because the University of California was using a quota system, correct?
Yes.
Okay, now are you insinuating that a quota system was used here, or was effectively they were just looking to develop a quota type of system without saying it?
Well, Your Honor, they were trying to have a quota system without actually calling it a quota system, so that way they could try and get around facing discrimination or picking out certain people.
Okay.
In the Bakke case, they also said that it was unconstitutional for them to make race an important factor and the main factor, as they're doing in this case today.
Okay, now in Grutter versus Michigan, Grutter was a student who was trying to get into law school, correct?
Yes.
And Grutter happened to be a white person where 79% of the applicants were white people to try to get into the University of Michigan Law School, correct?
Yes.
How does that apply to Abigail Fisher's here today?
Well, Your Honor, the Grutter case applies to the case at bar because they used the same logic in Bach. They say that that it is against the Equal Protection Clause, and that you have to not make race the sole factor, and you have to give people a chance with other races. They can have a quota system with races but to a certain point, not to make the quota system their number one priority.
Okay, now one thing I think it's interesting to note is that Abigail Fisher is a minority going to a school in which she is a minority of the potential pool of candidates, correct?
Yes.
In the Grutter case, she was not a minority in the pool of candidates going to law school, correct?
Yes.
So could one make a case that the University of Texas should have allowed her race-conscious affirmative action simply because of her being in a minority situation, correct?
Well, Your Honor, it's still discrimination, even if she was a minority or majority. We cannot allow race-conscious affirmative action, because then you're being discriminatory to the other races that don't fall under minorities.
And the parents involved in community school cases went in front of the Supreme Court. Could you tell us how that would apply here today?
Well, and the parents involved in community schools, in 2007, the court had considered affirmative action in the high school setting, and in there, they took into consideration the Grutter case, and I believe that they had the same opinion as them, saying that it had violated the Equal Protection Clause because it made race the sole purpose.
Okay. Now, the difference between the parents involved in community schools case, the major difference is that the thought of the people going to high school as going to college. High school is still mandatory, where college is not. Correct?
Yes, Your Honor. But even then, when considering, or for private schools or any school that you have to be admitted into and that you have to fill out applications for, you getting admitted into that school still shouldn't be based off of race. It doesn't matter where it is. You can't make race-conscious affirmative action because, once again, it is unconstitutional and against their Equal Protection Clause.
Okay. And the University of Texas has shown that use of race as a mission plus factor. Does it meet the strict scrutiny test?
Well, it doesn't meet the strict scrutiny test, the strict scrutiny test says that that it isn't valid because, again, it's going against their constitutional rights, and that the government interest and the constitutional right, or the government interest doesn't outweigh the constitutional rights that they have.
And also, the strict scrutiny test would be is that if Abigail Fisher is indeed a member of a minority group of students applying to the University of Texas, under strict scrutiny, would she not be considered to be advantaged of taking a part of the race-conscious university admissions program?
She would be an advantage since she is considered a minority. But even then, once again, we shouldn't have race-conscious affirmative action.
Right. Continue.
So going on, the admissions office should not be able to make their own legislation and try to change the future of students by admitting some and keeping others. There is nothing more than race-conscious discrimination. It is not legal and not within the original purpose of the admissions office.
Speaking about that, Counselor, compare that to like the early part of the Freedmen's Bureau. Can we really take away from one group of people and give to another group of people without legal benefit?
Well, Your Honor, you can't do that at all, and you see that in the Act of July 25th, 1868, in Chapter 245, Section 2, as they took out the Freedmen's Bureau because they figured out after a little while that taking from some and giving to another is unconstitutional and against their due process rights that they have in the Constitution.
Okay, now in the Act of March the 3rd, 1865, Chapter 90, Section 1, we see that the Freedmen's Bureau was started. What was the purpose of the Freedmen's Bureau?
The purpose of the Freedmen's Bureau was to help any slaves that were any slaves that were freed, to help them get back on their feet and help them start kind of like a life for them.
Okay, and how successful, how does this relate to race-conscious affirmative action programs?
Well, this relates to race-conscious affirmative action program because in the Freedmen's Bureau, they were taking from the majority and giving to the minority, trying to help them. And that's exactly what they're trying to do here. They're taking the admissions policy from the majority and giving it to the minority. They're giving the options that the majorities have to go into that college or not, and they're giving it to the minorities because they want to be more diverse. But as the Freedmen's Bureau did not succeed, as it got taken out in 1868, you see that it doesn't really work whenever you take some from others and take from one and give it to others, as it is against their due process rights.
Okay. Now, Counselor, it's kind of interesting. Dr. Martin Luther King was a famous civil rights leader, correct?
Yes.
And Dr. Martin Luther King belonged to the Republican Party. And what's kind of interesting today, we just recently had the election, I guess, in South Carolina, where Hillary Clinton received 90% of all the African votes in South Carolina. Do you see that there is a change in which African Americans are supporting more government programs or programs like this, or guaranteed? Is it helping or hurting African Americans when their success rate in college?
I believe that it is helping them whenever we start to take out the race conscious affirmative action. It's helping them because they're getting to know more about what's going on, and anybody is that has the opportunity to learn more about these things. They're getting more opportunities to learn about what's going on, how they can get into college, how they succeed in college, and how they succeed after that. So it's really helping everyone, but it doesn't help them whenever we have the race conscious affirmative action as they are starting to become the majority. So less get considered because they're the majority, and we have race conscious affirmative action.
And one corollary question to that: what happens to the high schools? In the state of Texas, we have the top 10 rule, a top 10% rule, where kids go automatically to college, and then the University of Texas is down to 7%. But what happens to traditionally high minority schools that get certain amounts of students in? Do they become competitive or non-competitive?
Well, that actually brings me up to my next point, that the top 10% rule is making more discrimination, and it's against the Fourth Amendment itself. Whenever you have the top 10% rule, you make schools less competitive. Because there are other schools that are way more competitive, that maybe people in their top 20% can have better qualifications for a university than people from people in a non-competitive school that are automatically in their top 10%.
Counselor, when you said the Fourth Amendment, you meant the 14th Amendment, correct?
Yes, the 14th Amendment.
Continue.
Thank you. So going on to say that in 1997, the Texas legislature approved of House Bill 588, which was created by Irma Rangel and Dinkinsville. And in this bill, it was a direct response to the 1996 Hopwood v. Texas decision by the Fifth Circuit Court of Appeals, which prohibited Texas universities from considering race in their admissions and financial aid decisions. Representative Rangel wanted to promote ethnicity diversity at Texas colleges and universities. And the concept behind that fact was that the ethnic diversity was becoming larger and larger in high schools all across the state of Texas. So if more high schools were to attend college, then more of the students would be diverse.
Okay, Counselor. Now, if the job of the the college admissions office is to secure the best amount of students to go into college, wouldn't it be better to improve the secondary high school situation to develop diversity instead of just getting diverse people coming through a system that's already flawed?
Yes, and in order to do this, we would have to take out the top 10% rule that Texas has adopted, because once again, it's just creating more discrimination by just accepting some but not others, or automatically guaranteeing some.
Do you have any personal stories or knowledge about this actually taking place?
Well, actually, at my school here today, we are not that much of a competitive school. So automatically the top 10% of students, even if they don't try, because more than I would say that about the top 8% really try. So the other 2% kind of just get automatically admitted into other colleges because this isn't a competitive high school, because there's not really a lot of high schools too close to this area to be competitive with. Unlike other schools closer to the city, per se, Westlake and Lake Travis, they're more competitive because they're closer to each other, and they're also striving to succeed more in college.
Mm-hmm.
So per se, like in those cases, in us and Westlake or Lake Travis, people in their top 20% could be better than people in our top 10%. But this happens because of the top 10% rule in general, and because it's a non-competitive school. So you take away the opportunities from people like that and give it to other people from a non-competitive school who could have lesser qualifications than other people.
Okay, continue.
Thank you. So the concept behind the fact that the ethnicity diversity was becoming larger and larger in high schools. And the problem was that with this concept was based on some faulty science. The top 10% rule sounds equal, but is it really? 10% of a graduating class of 30 would be 3, and 10% of a graduating class of 1,500 would be 150. But no one considered would the people in the group of 30 be as qualified as the people in the group of 150. This was the exact problem that was the subject of the UT Austin complaint in 2009. UT have worked with the Texas legislature to pass Senate Bill 175. In fact, they testified in the committee for the bill. The House Research Organization report in 2009 stated that Senate Bill 175 would maintain the benefits of the top 10% rule while giving universities the flexibility that they need to carry out their duty to all students in Texas. The admissions process of any university and exercise in both selecting qualified students with a high probability of achieving success and in crafting an entire class that serves the university's missions. Higher education experts and administrations are well aware of the need in Texas to expand higher education opportunities to all citizens, especially those who have historically suffered from discrimination. Since the enactment of the top 10% law, however, universities have been required to admit all applicants who graduate in the top 10% of their high school class, which has had significant negative consequences that the bill would address. Texas universities should address the needs of Texans, including the other 90%. We need to fix our schools and our school systems to provide a world-class education to all students. We cannot educate or should not educate just the top 10 students. Many top-notch students whose GPA do not rank them in the top 10% are being overlooked, even though they are extremely well prepared and successful students. This is especially true for those in larger urban high schools where academic competition is fierce. Until additional Tier 1 institutions are established in the state, the law is enforcing many top-notch students who are not in the top 10% to out-of-state universities, creating a brain drain of excellent students that should be in Texas institutions. Current law requires state universities to admit certain based on single criterion, class rank. That limits an institution's flexibility and creates one-dimensional, unhealthy academic environment. According to a report from the National Association for College Admission Counseling in 2006, the top 4 factors of admissions decisions in the college and universities are grades in college preparatory courses, the strength of curriculum, admissions test scores and overall grades. Class rank is listed 6th in the order of importance. Basing admission on the single criterion deprives the campuses of well-rounded freshman class that reflects the diversity and excellence of the state. And on to the 5th point. The unintended consequences of the top 10 law in court cases result in even more discrimination. The unintended consequences of the aftermath of House Bill 588 and Senate Bill 175, the top 10 rule, and Grutter v. Bollinger are seen in increased discrimination for various students that these alleged rules or bills were trying to help. In essence, the University of Texas has created their defense by justifying a decision that is unjustifiable. They defended the top 10% rule by saying it is the law, even though it is discriminatory and hurting the group of people that they should be supporting, students trying to get into college. In 2001, the Texas Monthly magazine published an article by Patricia Hart entitled The Imperfect 10. The opening paragraph of the article could be easily as relevant today as it was almost 15 years ago. 12 years ago, Fort Worth attorney William D. Rutledge scouted the local schools to find the best environment for his son, who was starting kindergarten. He settled in Trinity Valley School, a private school renowned for rigorous curriculum and small class sizes. It was a natural choice for a father determined to provide the best education for his son. Last year, Rutledge removed his son from Trinity Valley and enrolled him for his senior year in Arlington Heights, the public high school for Rutledge's southwest Tarrant County neighborhood. Why the FNO? Because the Trinity Valley does not rank the 87 students in its graduating class. His son couldn't be in the top 10%, but at Arlington Heights, the younger Rutledge grades point average will easily earn him a spot in the top 10% and a precise entitlement that comes with the high school class ranking. Some parents in some high schools have become super competitive. These schools are offering their students opportunities like college-level classes in almost every area: PE, electives, foreign languages, and in all core classes. Other schools are offering early college start, obtaining an associate's degree in college even before you graduate from high school. Still, other colleges are offering programs that offer opportunities for almost a 3 years worth of work in college for their high school graduates. Instead of making things more equal, House Bill 588 and Senate Bill 175 have made things more uneven, and the unintended consequences of race-conscious admissions has been to hurt schools that are poor or unable to offer all these other programs. This includes many inner-city poor high schools and poor rural high schools all across the state of Texas. The untold story here is that if you go to the program that offers a great deal, you will learn a great deal. More if you go to the school that offers you not as nearly as much. You can still get into the school because of the top 10 rule, but your chance of graduation from that institution is diminished. How can students who come from poverty and limited opportunities compete against people who have unlimited opportunities? The answer is a difficult one to face and a much more difficult to answer. The real discrimination here is against poor people who send their students to public schools, who think that their students are prepared to go to college because they were accepted, only to find out that once in college, they were not prepared. This is a discrimination the state and University of Texas should be addressing. Can the poor schools in Texas actually compete with the more wealthy schools in our state? Success is determined by the top 10% rule. Yet the college does not really depend upon this because there are so many more factors to consider. We pray that you vote against the lower court's ruling and uphold the rights of Abigail Fisher, who has done nothing but fought for the rights of students across the great state and nation, and stand up and say no to discrimination. Discrimination by poor schools, discrimination by race, and discrimination by failure of our institutions of higher learning to be transparent and upfront with parents, students, and taxpayers. The University of Texas clearly should have admitted Abigail Fisher in 2008. Her graduation from another university in 2012 proved this. The University of Texas in 2009 lobbied and charged the top 10% rule because they thought it limited their ability to attract good candidates. Is race-conscious affirmative action consistent with the 14th Amendment to the United States Constitution? The answer is a resounding no, and you should vote to correct the injustice that was done to Abigail Fisher. Thank you for your time.